That's good. It's the whole world.
All right.
Sorry.
All right, guys. Well, let's go ahead and get started. I want to introduce you guys to Gretchen Ortiz. Gretchen is actually, believe it or not, an agent with us here at FRI, but she is also a brilliant real estate attorney. And she is, I'll let her do a lot of her own introduction, but I can just tell you she's brilliant and she's helpful for you guys. And she's actually got some offers for you guys to help you with your real estate needs. And she is very well versed on the changes to the revisions to the as-is contract. And I'm going to let her take over. Gretchen, I'm going to make you the host in case you want to do screen sharing or something like that. And I will let you get started. Everyone, Gretchen Ortiz.
Good morning.
Good morning, everyone. Thank you all
Good
for
morning.
being here. Hope you're having a wonderful Thanksgiving week and are getting ready for Thanksgiving tomorrow. My name is Gretchen, like Ryan said, my name is Gretchen Ortiz. I'm a real estate, probate and business law attorney. I serve the whole state of Florida. We have offices in here in Orlando, Maitland, and in St. Augustine. Ryan, can I share my screen? Yes, okay.
Here we go.
It's working.
Okay. Okay, so a couple of things before we get started. Hope you all have a copy of the contract with you or have access to one. This webinar is not intended to give any legal advice. If you do have any questions or have clients that have questions, please contact legal counsel. This class and webinar is intended just to discuss the revisions and updates to the contract as of November 1st. Our objectives are to review those updates and revisions to the Florida Realtors and Bar contract. And I'm also going to provide you, this class is usually 2.5 hours long, or I split it into part 1 and part 2. So if you're interested in that I go over the revisions to the writers and to explain the additions to the new writers, please let Ryan know and we'll go ahead and schedule that. But I will provide you with the list of the revised writers and also a list of the additions, the new writers. So we're going to be going over both the for sale and purchase and the as-is contract. And the reason why I mentioned this is because you know that FAR has their own contract and addendums that's completely separate from the Florida Realtors and Florida Bar Residential contract and the Florida Realtors and Bar Residential as-is contract. So before we begin, there are minor changes. I'm only going to touch up on those, but I will dive deeper into the major changes which occurred around the financing clauses. If you have any questions, feel free to just unmute yourself and ask your questions, raise your hand, or you can just put it in the chat. And as I go through, I will answer any questions that you may have. Okay, so the list of revised writers is this one here. So the HOA community disclosure writer was revised and some clauses were added to those. The FHA and VA writer, the right to inspect and the right to cancel, the pre-closing occupancy by the buyer, which we'll touch up a little bit on today, the post-closing occupancy by seller, the sale of buyer property, and backup contracts. All those writers were revised. The new writers are the mold inspection, the seasonal and vacational rentals post, which means after closing, and the property assessed clean energy disclosure, the PACE writers. Those are all new writers. And like I said, if you want me to go in depth into these revisions and the new writers, just shoot an email to Ryan or myself and we can schedule a class for those. Okay, so let's get started. We'll start with the first clause on the contract. In this, the property description, as you can see, the only item that was removed was the intercom, and everything that was added on there, I've highlighted for you, which basically was the thermostat, doorbells, television wall mounts, television mounting hardware, mailbox keys were included on there, as well as storm protection items, and the intercoms, like I said, were removed. One of the important revisions that were made to the contract was to the closing, the definition of closing and the closing date. The definition of closing now includes that a closing occurs when all funds required for closing are received by the closing agent pursuant to the standard S. This basically means that before, the closing would occur when the seller was in receipt of funds, but it's not like that anymore. The closing occurs when the closing agent receives all the funds that are required for closing. So this is very important. Go ahead and highlight this because it is one of the most important revisions. The extension date. So the extension period for closing date provided under the CFPB has been reduced to 7 days instead of the previous 10. And and it also clarifies that the extension is not only automatic. It's only automatic if the loan was approved, meaning all the seller requirement, all the underwriting requirements were completed prior to the originally agreed upon date. So this basically means that if the loan was approved, if all the underwriting requirements were met prior to the closing date, then automatically the closing date will automatically extend to 7 days instead of the previous 10. On clause 6, the only changes to this clause was that it made reference to the new rider, the rider T, which is the pre-closing occupancy by buyer. So I will not touch up on this because it's not that, that's just the only reference that it made. So if we do a class where we go into this rider, I will explain what the changes are to this and what it means, this new occupancy rider. On 6B, it was added that seasonal and short-term vacation rentals was added, as you can see on there highlighted in yellow. And also very, very important that the estoppel letters are not required on seasonal or short-term vacation rentals. So now you want to make sure that if you represent a buyer, that you request, if you want to know that you request that, because it is not required on seasonal and short-term vacation rentals. As an attorney, I will always recommend that you request the estoppel. However, it is not required. So you want to make sure that you put a notation on here that if you're representing a buyer, you want to make sure that you request it, as it is not required. On number 7, a default clause was added. So if no box are checked in number 7, the default is the buyer may not assign this contract. So as before, this clause was not there. Now it is added on there. So you want to make sure that if this is a contract that can be assigned, that you check the boxes, because if no box are checked, then the buyer may not assign the contract. Now we go into the major changes which occurred around financing, like I said before, and it starts with number 8. And number 8, 8A, now is back to a cash transaction with no contingency financing. And this is going to make a lot of sense when we go over the financing changes, because this changed the whole game. So we are back to the cash transaction with no financing contingency. So it was simplified. And this is where all the major changes start to occur. So on 8, the loan approval period includes the approval of financing, as you can see on here. Changes to the loan approval period include both the approval financing, which means the specific terms of the underwriters have been approved, but it also adds that there needs to be a receipt of an appraisal that is satisfactory to the lender. However, if you see here on the contract, one of the major changes was the addition of an alternative valuation. So the definition of appraisal now includes, and it has been expanded to include the alternative evaluations if applicable to the buyer's lender. So basically now there's two things that that must be met. There's two parts to this. The buyer has to be approved, and the lender has to receive a satisfactory appraisal or a valuation, an alternative valuation to the appraisal. So this is major because one of the reasons why this is done, one of the reasons why this has been added on there is because if the lender has not received a satisfactory appraisal, then they're not approved for the loan. So they both have to be met in order for the loan approval to be quote unquote be a loan approval. Any questions on this area?
Yes, quick question, please. Can the buyers can they come up with the difference between appraisal?
I couldn't, can you repeat?
Can the buyers come up with the difference between the appraisal, even if it has to come up to a satisfactory amount for the lenders?
We'll go over that in a little bit, but basically, yes.
Okay.
But it
Thank
has
you.
to be, the appraisal has to be, the importance here is that it's satisfactory to the lender. So in order, the loan approval, it has to include the approval of financing, and it also has to include a satisfactory appraisal if required. In 8B1, there's been many changes. And basically those are these two. So AB1 redefines loan approval to mean that loan approval hold on one second. So it redefines loan approval to mean that not only does the lender have to loan the buyer funds, but it adds that an appraisal satisfactory to the lender is received. So as like we said in 8A, 8B1 redefines that word loan approval. And it also revised this section, which is very important. And it says loan approval, which requires the buyer to sell real estate property, is not loan approval. Whereas before, if there was, if the loan approval could require a buyer to sell real property, and if that happened, that was part of the loan approval process. Now it is not. So it is very important that you highlight this fact, because now the only way that happened is unless writer V, the sale of buyer's property, is attached. So loan approval, which requires the buyer to sell real estate or real property, is not loan approval unless writer V, sale of buyer's property, is attached. So you want to make sure that if there's going to be a sale of real property, that writer is attached to the contract. So that's why it's very important to understand the new writers and the revisions to the old writers as well. With section 8B2 of financing, another major update. So basically with this update, the buyer's duty to keep, if you remember in the previous contract, or if you have a copy of the previous contract, you will see that the buyer had a duty to keep the seller informed of loan approval. Now they don't have to unless the seller sends a written request. So the buyer doesn't have a duty to keep seller informed, or they do have it only if the seller sends in a written request. So This is very, very, very important because now a buyer can wait practically till the end of the loan approval period to let the seller know whether they're approved for the loan or not. So you want to make sure if you represent the seller, if you're the listing agent, and you want to keep informed as to the loan approval process, the appraisal, or any property related conditions, that you send in a written request to the buyer's agent to obtain that information.
Excuse me, can the
Yes.
written request just be an email?
We'll go over that when we get to communications because that's also changed. But basically it can be an email, it can be a fax, or it can be a letter. But it can no longer be a text, and we'll go over that when we get into communications. But the important thing here is that that the buyer can now wait. So it doesn't have to keep the seller informed, or that is, unless it is required by the seller in a written form. B3 was completely revised. So let's go over this. Okay, so now the revisions were this: buyer has now until the end of the loan approval period to inform the seller of loan approval in writing. That's why in the previous slide, I said, if you're the listing agent and you want your sellers to be apprised of the information of the appraisal, the loan approval, of the property related conditions, you want to make sure that you send that that letter, that email, so that you obtain that information, because they can now wait until the end of the loan approval period to inform the seller in writing. They also, the buyer does not, if the buyer does not obtain loan approval within the specified loan approval period in the contract, they still can move forward to closing, provided that the buyer, there's two items here. The buyer is satisfied with the ability to obtain loan approval to close and delivers written notice of this to the seller within the loan approval period. So let me explain this to you. So basically, let's say in the contract, the buyer has 30 days to obtain loan approval. Let's say within those 15 days, they didn't get approved for the loan. That doesn't make it an automatic termination. It doesn't mean that there's an automatic cancellation of the contract. What that means is that the buyer, if they feel satisfied that they can obtain another loan approval, they can go ahead and try with another bank or with another lender within those 30-day period, as long as they inform the seller in writing. So it's not like whereas before, if it was 15 or 30 days and if they didn't get approved, they would inform the seller in writing, and that was it. No, now they can proceed to closing. They can even proceed to closing with Section 8A as a cash transaction. They can proceed to closing if they feel that they can obtain loan approval to close, as long as they deliver. So this is a major, major update, and you want to go ahead and make sure that you highlight, make notes of this, because they can go on. So if you're representing the buyer, you can understand that they can move forward. You still have those 15 days if it's 30 days. And if you're the seller's agent, you want to make sure that you give a proper amount of time. If within that amount of time, if they don't get approved, you want to move forward with a backup contract. So if you want to give 15 days, because they have that time frame to obtain a second loan. Any questions on this section? Because this was one of the major updates to the contract.
Can you explain that one more time? I'm sorry.
Yes. So basically with Section 8B3, okay, it was revised so that the buyer has now until the end of the loan approval period to inform the seller of loan approval in writing. If the buyer does not obtain that approval, so with it, let's say it was 30 days, for example, the buyer has 30 days. Your buyer has 30 days to obtain loan approval. If the buyer does not obtain loan approval within those 30 days, they can still move forward with the closing within the specified time period in the contract. So if it's 30 days, they can still move forward. They can move forward with Section 8A as a cash transaction, or they can move forward if the buyer feels that they can obtain a loan approval with another bank. So let's say they had the loan with bank A fell through, but there's still 7, 10, 15 days left in their loan approval period. They can still go to bank B and try to obtain a loan approval with loan B, as long as they deliver written notice to the seller within the loan approval period. So it doesn't end with when the buyer does not get loan approval. They still have time. So this is a major update. Was I able to clarify your question?
Yeah, as long as they're within the
Loan
time
approval period.
on the
Yes.
contract. Yeah, if it goes over that period, then it's done.
You could
Correct.
extend that period in writing, correct?
Right. Oh, you froze, Gretchen. Come on, Gretchen, come on back.
Yeah, clearly she's frozen. Yeah, of course you can extend the period.
Yeah.
I'm not sure what she's talking about with the other thing. It's a good question. But yeah, we'll wait for her to get back.
So does this say if you have the buyer, you have to do a written notice to the other side? Like, what if you just kept going on?
No,
and
what
you
they're
don't-
saying is previously the listing agent can call your lender all the time, every day if they
Right,
want, and annoy them
right.
every day. Now they have
Yeah.
to ask you for that in writing,
Right,
which they will. But what was happening was people were trying to wiggle out of contracts on the seller side by saying, oh, the buyer was supposed to keep us informed, and they never did. Well, if you never, they were doing it after the deal would fall apart, or they wanted to keep their deposit or whatever, and they'd say, oh, they weren't keeping us informed. Well, now they're saying, well, you have to make an effort too.
right.
If you
But
want us to
I'm,
keep you informed. you
but
have
what
to
I'm
make it.
saying is, when you get loan approval, you're obligated to put that in writing to them? Because I don't know that was so.
That's a good question. I don't. That's never really been a thing. Usually, agents
Right.
blow right through that, assuming
Exactly.
your client is fine. You're fine, and some of you guys have blown right through it, and some of other people's clients have blown right through it without even paying attention to it. And then they don't get saying, "Oh my gosh, it's day 32, and we just got rejected." Well, you're supposed to be on top of that.
Yeah,
So
I'm on top of it. I just, a lot of times in deals, the other people don't seem that concerned about the actual time frame, which I am. But so that's all. I'm just wondering, are we obligated to inform the other side, if they're going forward, that basically.
yeah,
So I think
well, you've always
think
been
the
supposed to
change-
do that.
I think the change is once we go under contract, we need to send an email immediately so that we can be
Yes.
notified of any kind
Exactly.
of loan process,
Exactly.
which sometimes I do, sometimes I don't, but it sounds like I need to do it all the time.
Well, I'm neurotic, so I call those people all the time when I have the listing.
I understand.
I think you guys should probably make it part of when you're the listing agent, make it part of your process. When you get the thing, thank you very much for the contract. Here it is, all executed, ready to go back to you. By the way, we'd like to be informed of all progress. Just make it part of your form letter if you guys have one for when you get a listing under contract, or when you send it to the title company and back to the agent, just have a template or something you send.
Ryan, I had a question in regard to talking about when, like, in the past contract before it updated, where the buyer's agent would have to keep the seller's update on the progress of the loan. But not honestly, when we as agents have that good relationship with the other side, we just communicate to each other, hey, how is the loan going? So on the old contract, technically, if the buyer didn't tell the seller that their loan was approved, then the seller could technically get out of contract because they were not told. And that usually was really enforced or happening because, each party would want to close anyways. So with that specifically buyer's agent duty right now with the new contract, do we have to send that email in writing saying that the loan has been approved, knowing that even if it's been approved under conditions, is that considered being approved if it still has conditions to be met?
Well, there's always going to be conditions to be met because you haven't closed yet. And there's always the condition that you don't go out and buy a new car tomorrow. Okay,
Ryan,
so
I'm
she's
here.
back. Okay, Gretchen's back, guys. So Gretchen, they've got a bunch of questions for you, and I'm so glad that you're back because you can answer.
Okay, so let's go ahead and finish the presentation and then we'll go through the questions.
Okay. Well, let me make you the host again. Sorry.
Yes, please.
Okay, you should be the host. Okay, you're good. You're back on.
Okay, so I think we stopped here. Okay, so I think we're good now. Okay, so we stopped here. Now with AB, IV, the changes here is even if buyer obtains loan approval, another major update. So even if buyer obtains loan approval, he may still terminate and get his deposit back, provided that the buyer cannot meet the terms of the loan in a timely manner, and provided that he delivers written termination, a notice to the seller prior to the end of loan approval. So again, major updates. So even if the buyer obtains loan approval, let's say the underwriting conditions came back and he's not able to meet those conditions in good faith, like on here, I highlighted for you the word good faith and diligent effort. If it's a good faith and he made his diligent effort to meet the loan requirements, but he just cannot, he may still terminate the contract and get his deposit as long as he provides the seller with a written notification of this before loan approval. So another major update. ABV, another major update, take notes. In here, if the buyer fails to provide any written notice to the seller, and this is all for the listing agents, for those that are representing sellers, if the buyer fails to provide written notice to the seller during the loan approval period, the transaction moves forward as if Section 8A had been checked. Remember, 2 slides ago, I told you that even if the buyer doesn't get loan approval, if they're still within the loan period, they can move forward with closing. This is one of the benefits for them. They can still move forward to closing as if Section 8A had been checked, like a cash transaction, unless the seller timely terminates the contract within 3 days after the expiration of the loan approval. So again, if the buyer fails to provide any written notice to the seller during the loan approval period, because remember, the seller has to request that in writing, the transaction moves forward as if Section 8 had been checked. So let's say, I'm going to give you a scenario. You have a buyer, you have a seller, the loan approval period is 30 days. The buyer did not get approved. He can still move forward with closing. If he feels satisfied, he can get loan approval for another bank or as a cash transaction, unless the seller terminates the contract within 3 days after the expiration of the loan approval. So the seller will have to wait after that termination of the loan approval period to go ahead and cancel, because the buyer can still, after the loan approval, provide the seller with written notification that they're satisfied that they can get loan approval. So you want to make sure that if you're representing your seller, that if you're the listing agent and the loan approval period has passed, that you provide those 3 days, within that 3 days, you send in written notification. So make a note of this, because this is another major update to the contract. ABVI. The buyer can also terminate and get his deposit back. And this is some of these are as the same as they were before. Of course, if the seller defaults, if they cannot meet any, if the seller can't satisfy any of the contingencies, or property related conditions of loan approval, which excludes the alternative valuation, have not been met, unless it is waived under the contract under other provisions. So buyer can still terminate and get his deposit back if the seller defaults, if the contingencies can be met, or property related conditions of loan approval, which excludes the appraisal or the alternative valuation, have not been met, unless it is specified as such in other parts of the contract. So what I would recommend in this scenario is just to have an addendum to draft specific, to be specific as to those terms and conditions, so that if you're representing the seller, of course you can, if you're representing the seller or if you're the listing agent, you can have your listing agent, your seller covered in a situation like this. So another major update, you want to make sure that you understand this, because there's already three slides that I've gone through where the buyer can still get his deposit back if there's issues related to loan approval, property related conditions, and appraisal. So very, very important that you make notes of this. Contract revisions to number 9, which is closings, title insurance, survey, home warranty, special assessment. So basically on the cost to be paid by seller, they added FERPTA on there. So FERPTA, if it's applicable, it is paid by the seller. Section C, title insurance and title evidence and insurance, if it's in the Miami-Dade area or in the Broward regional area, the buyer designates the closing agent in those areas. And the survey, the date changed to at least 5 days before closing. So whereas before they didn't have any specific date, now it changed to 5 days before closing. And then another major update within this area was Section F for special assessment. So it adds that if any prepayment are permitted, if any prepayments are permitted, seller shall pay at closing. And it also adds this, it adds that special assessment by a special district, if they are applicable, will be prorated. So those are the changes that were made to number 9 for closing cost.
Excuse me, Gretchen, I have a question on that.
Go ahead.
Are we saving questions for last?
Yeah, we're saving questions for last, but go ahead.
In regards on that section 9 about the FERPTA being added for the seller side, does that mean that the FERPTA addendum will not longer be needed? Or do we still have to attach that FERPTA addendum with the as-is contract?
I will do both. I mean, it's there. It's there. They added it to the cost paid by seller. FERPTA is paid by the seller. So it depends on your preference. I would add it because I like the protection. However, it's there. So you want to make sure you check the box. You highlight it. You have, if you represent your buyer, you want to make sure that I always like to have them initial that section just so that they understand what the seller costs are and the buyer costs. Because remember, everything is negotiable, so it's added to the seller side. So I would add the addendum, but it's completely optional at this point because it is added under section 9.
Okay, thank you.
You're welcome.
But doesn't the FERPTA currently make the buyers take responsibility if they're not going to live in the house for like 2 years? I'm just kind of going off the top of my head. So it kind of seems like it contradicts each other.
Well, I will go through that when I'm done with the presentation. I'll answer that question when we're done with the presentation. Okay. Another revision 18F is the time is of the essence in this contract that has been added. Time zones. Hold on 1 second. I wanted to mention something about this. Okay, so time zones, on 18F, it adds time zone for property. It also adds the observance of holidays. And it removes the 5 p.m. If you remember back in the old contract, we have the 5 p.m. cutoff for automatic extension when it ends on a Saturday or a Sunday, but now it's not like that. Now it defines a public holiday. It expanded the definition of national legal public holiday if it is observed. It also adds and it specifies what happens on a Saturday or a Sunday and how it shall extend. So as if we already didn't have any problems with all these dates, now we have to make sure that we read this and we make sure that we take this into consideration when we're drafting, when we're preparing the contract and we're looking for dates, because this all were added on there. So it expanded, I'm looking for my notes on here, 1 second. Okay, so here it is. Here are my notes. So in regards to this, the new version of the contract states that a calendar day will be based on where the property is located. So that's for the time zone of the property. It clarifies the calculations if a date or a time period ends on a Saturday or a Sunday, and or if a day is a national legal holiday, or on a day that a national legal holiday is observed. So all of those have to be taken into consideration, and it is all clarified within this section, this clause of 18F. So they have to be taken into consideration when you're drafting your contracts. So make sure you read over the contract. I always tell all the realtors, and as a real estate attorney, you know, before I became an attorney, I had 20 years of real estate experience. I owned a title company, a mortgage, and a real estate company. Now as a real estate attorney, I take that experience and my legal experience, and I've combined it to provide the best representation for brokers, realtors, sellers, and buyers. And one of the main things that I always tell my realtors is that you want to go over the contract, especially now with all these changes that have been made. You want to read each section, you want to understand it, and you want your buyer and your seller to understand it as well, so that there are no issues, and so that you protect your seller if you're representing your seller, or if you're representing the buyer, you also protect. And if you're a transactional, you're representing both, they both understand what they're getting into, because all of this have they have legal implications in their back. So you want to make sure that you understand it. Force majeure was another major update, of course, because of all that we've been going through. The force majeure was added on there. I highlighted I highlighted everything that means a force majeure, which is civil unrest, governmental action and mandates, government shutdowns were added, epidemic or pandemics. And it also specifies when the force majeure begins. And it includes a section on here that tells you until when the force, if you see on here where it says all time periods affected by force majeure events, including constant, will be extended for a reasonable time up to 7 days after the force majeure. It tells you when it will end, and it tells you if it has to be extended, for how long it should be extended. So you want to make sure that you read that that section when you're drafting your contract, so that all those dates are also taken into consideration, because this is all things that we are fixing right now, and they're all important, so they're all being added to this section. So basically it expanded the performance and contractual rights. This section also expanded on the walkthrough. So you want to make sure on the walkthrough of properties. So you want to make sure that you read and understand all this section. 18K. 18K added what we went over before, except that it highlights the statute that applies to special assessment and special districts assessments. So those will be prorated, and it includes special benefit tax assessments, CDDs, and they are all expanded and defined in this section. So you want to make sure you understand that. So when you're working with your closing agents and they're doing the prorations, you go into your appraiser websites and you make sure if the special districts assessment apply or if they don't apply, depending on which party you're representing. Other revisions that are major revisions are the communications revisions, 18O. So this was one of the questions that was asked. The delivery of communication, it's specifically by mail, fax, or email. So if you see, it excluded other forms of communications like text. So the reason why they did that is because if you know WhatsApp, applications like WhatsApp and Telegram and other applications that were being used to test back and forth between realtors, between brokers, between buyers and sellers, those apps now have the ability to make messages automatically disappear, to make messages, you can erase those messages, and so they're not considered a writing. They're not considered an effective form of communications. So now it's specifically by mail, fax, or email. So that written request from the seller to obtain the buyer's information as far as the loan approval has to be sent by email, by mail, or by fax. So make sure you highlight these sections because this is very, very important. Number 19 also included bosses for the new writers. If we have a class and we go through the new writers, I will explain what the revisions are on the old writers and the new writers and how they are applied. But section 19 includes the bots for all the writers. The list of writers that I provided to you in one of the slides. It also, this is another major update. It's that a seller has no longer has to reject in writing. So it removed that box of rejection by seller. That box was removed. So now the seller does not have to reject in writing. It only adds the counter offer. And so now I will open up, I will remove my slides, but before I do, go ahead and take my office information number down. That mobile number is specifically for the realtors of Florida Realty Investment. If you have any questions, you can shoot a text to that mobile phone number. And if you want to request a consultation that will take longer than 10-15 minutes, go ahead and send an email to info@GretchenOrtizLaw.com. I've also provided you with my webpage. And I also want to mention I'm a title insurance liaison with the Real Property and Probate Trust and Land of the Florida Bar. And I serve on the commercial committee. So if you have any questions as far as title insurance, closings, we do closings as well. Just feel free to reach out and ask any questions. We're happy to help all the realtors, especially because I'm one of the realtors at Florida Realty Investment. So this is just being provided for you. Go ahead and take that mobile phone number down. So now I'm going to close so I can answer questions.
Gretchen, on the first slide, you had highlighted personal property, but I don't think you mentioned anything about it.
On the first line.
The very first slide.
Yes, I'm going back to that slide. So on the first slide, they just removed the word intercom and added, let me go back to that slide 1 second. So they added thermostat, they added doorbells, television wall mount, television mounting hardware. They added mailbox keys as part of personal property, storm protection items and hardware. So all of those were added and the intercoms were removed. So, and I highlighted the ones that were added for you. So that was the only change that was made to personal property.
Okay, thank you.
What
And,
about questions regarding new builds contract? Was there any changes to the new builders with their contract or just this far bars?
It was just with, it was for the Florida Realtors, bar contract. There were changes for the builders, but those changes, I mean, we'll have to have another class on those contracts because builders contracts are usually drafted by attorneys. So they include a lot more clauses. And Ryan, if you ever want to do like a new builder contract, because I do get a lot of realtors that are running into issues with new homes sales, because those contracts are specifically drafted by attorneys for builders. So, but everything's negotiable. Everything is negotiable as far as a contract is concerned. So you want to make sure that you read those contracts as well, because they tend to benefit the builder. Just this past week, I had a buyer that lost almost $30,000 based on a clause that was on that contract that had the contract. Had I reviewed the contract, I would have negotiated that term. So I always recommend all of your realtors to have 3 people on your side. You want to have an accountant on your team, you obviously your broker, but you always want to have a legal advisor, because a review of a contract may cost the buyer or the seller maybe $300-400 to begin with, but what they will save in the long run, it's a lot more. Like this buyer lost $30,000 because unfortunately he had initial right next to the clause that gave the builder the right to keep the deposit in case that specific situation occurred. So you always want to make sure that you advise
Come on, Gretchen. All right. She back? No. All right. We may have lost Gretchen. Hopefully she comes back. I can't tell if she's gone yet. So you guys pay attention to what she's saying there. You know, part of what she does, obviously, big part of what she does. Yeah, and she's gone now because I'm the host again. Part of what she does is a lot of what she does for a living is help you guys with stuff, and she's willing to give you guys some free consultations and stuff like that, which is really cool. So take advantage of those things. And it's very nice for her to do that. And she'll be back to talk about other things. So you guys make sure that you update me on things that you would like to hear about from a lawyer's perspective. And some of the things that she mentioned, obviously, and she'll be willing to do that for you guys. So I think she mentioned the new home builds. She mentioned a couple other things as well. So you guys let me know if there's something else you'd like to hear from her on. And she gave you guys her cell phone number, which you probably don't have many attorney cell phone numbers. So if you need some attorney help on stuff, she'll be willing to help you guys. I think she told me she'll give you guys 15 minutes at least of a consultation or something like that for free. So that's probably what you guys need on a lot of stuff. Okay, Ida wants to see the new builder contract. All right.
There are more changes that I realized there was.
Yes. Yes, there are, and some of them are just cleaning stuff up, stuff that they've had, and that happens because the last one they did was some major changes with the whole loan approval period. Got rid of the loan, loan commitment.
Yes.
And they got the loan approval period, which caused obviously, and then you got all kinds of different interpretations, and the only way to get through these interpretations is to sue. And so people would sue people, and now they want to clean up the legal dockets. So they're trying to be more specific on things, like we talked about with notifying, the buyer, keeping you updated on that. Well, who's to decide what updated is? If there's Gretchen's back.
I'm so sorry. So we left off in the builder question. And I'm not sure where I left off, but what I was saying is, as a realtor, you will build more credibility if you do that. If you advise your buyer, hey, listen, let's sit down with a legal counsel, let's review this contract, because at the end of the day, if they run into a problem and there was legal counsel involved and the contract was reviewed and the terms were negotiated, that they wouldn't be in the position as this buyer that I just had last week that lost $30,000 because they initial that specific clause. So always, you know, just suggest it to your buyers. Let's just go ahead and have an attorney review the contract so that it's in the best interest of your buyers. Any other questions?
I have a comment, Gretchen, on that real
Okay.
quickly. I know your time is valuable, so I just want to point out to you guys, because we have this conversation from time to time about them showing their clients' houses, and then, oh, Sunday afternoon on the way home from church, they stopped by this new home place, and the salesperson there told them that I can save you money if you don't use a realtor, and you know, all this kind of stuff we keep hearing about in these meetings. Well, you guys need to get this out on your social media. You guys need to get this information out that these contracts are drawn up by
Attorney.
D.R. Horton's attorneys for D.R. Horton, and they are set to get the best of you and your client, and not, they're set to do what's best for D.R. Horton. It's not like using an as is that's supposed to be fair for everybody. They're set up to take advantage of your client and all these things. Like she said, there was a clause in there for some specific reason, and they're going to lose their money. Your clients don't know that. They're not used to that. You guys aren't used to that. And so make sure you get out there in your social media marketing and any kind of your marketing and any kind of sit down that you have with your clients. Make sure that if you stop by a new home builder, we go over this contract together. Do not go without me, because you will not be represented. And then when you actually have someone like Gretchen to help you, that is putting you over the top and giving you, like she said, credibility, but it's actually providing a service. And you need to make sure people know that you're providing a service, because people don't think you provide a service, especially when someone tells them, oh, well, I don't have to pay your agent 3%. That's going to save you, you know, $17,000. So anyway, sorry, Gretchen.
And
Any
just
questions?
to piggyback, yeah, and just to piggyback on what Ryan said, there's a very thin line between, you know, the unlicensed practice of law. So I mean, I totally understand when you get these contracts, most of the real estate agents don't understand those clauses either, and you don't want to get to a point where you start explaining to your buyer what those clauses mean, because I've also had issues where buyers are suing the realtors because the realtor said, oh no, this just means that you're okay, go ahead and sign, and then when the issue comes up, well, you know, now they're in trouble because they were the first ones to tell their buyers, yes, go ahead and sign. Everything looks good. Everything looks fine. This is what it means, when technically it didn't mean that. The legal language tends to be a little complicated. So you don't want to put yourself in that position. You want to say, this is not the normal contract that we use for to sell just normal residential real estate or resell. This is a contract that is specifically for this builder that has been drafted by their attorneys or by their company. So we want to make sure just that we, you know, just to that you're safe and that I'm okay, that we just review it with our attorneys so that you build credibility and you build that relationship. And like Ryan said, you can also, you know, put it out on social media that you're providing that service.
But you have to provide that service through someone like Gretchen. So you don't say, oh, I'll look through that contract for you. Yes.
Exactly.
What it
Don't
seems like
take
to
on
me,
what you don't need to take on. Don't take the liability.
most of these revisions, what it looks like to me, they're much more geared towards financed buyers. I'm speaking as a listing agent myself. It sounds like they put a lot more emphasis on buyers financing, and they put a lot more liability on realtors. It's exactly what it looks like to me, because now I have to look at more dates. I have to be very particular on the financing for my buyers, or for the buyers of my properties that I've listed. I think it's much more liability for us.
It is, and that's why we're going over it, because yes, it was most of the major updates occurred around financing, and I think especially because of the market, the way the market is now, and you know, the with everything that we went through last year with the pandemic and all the civil unrest and everything that we went through. So for listing agents, it's going to be a matter of being more detailed. So instead of just drafting a contract, whereas before it was just drafting the contract, sellers signed, and all the responsibility was put on the buyer's agent, now I think it's more of equal parts. So you have to, now you really have to negotiate those dates. You really have to make sure that you read over the contract and explain it to your seller, and that you set the right expectations. So if all those three things are done, then you're going to be okay, and the liability will be minimized. And when we go, Ryan, if we do set up a class for the writers, because it takes me like an hour to go over the new writers and to describe the revisions to the old writers. Those writers tend to favor the seller in some way because they're added on there for their further protection. So you want to understand those revisions and you want to understand what the new writers entail so that you can add it on there. So be as specific as possible. And yes, you will have to take more time, but just take those 3 things into consideration and you'll be fine.
Ida, Idul, Bridget, and Jose, some of them by private message, want to know what it is how much it is to review a contract.
It all depends on if it's just the Florida Realtors FAR bar contract is less. Builder contracts tend to be more especially because each builder has their own contract. And I see builder contracts that are 50 pages long and they have so many clauses. So remember, a review is just one price range, but if you want me to review and negotiate the contract, that's going to be particular to the case. So the best bet would be just to call my office or just to shoot me a text and let me know what's going on, what particular transaction, the amount of the transaction, what you're trying to do, and then we can quote you on that. Our prices are very reasonable because, like I said, I myself was in the real estate industry for over 20 years and now try to provide reasonable prices so that realtors are protected in that way. So I advocate a lot for realtors, being in the real property, probate and land trust. With the Florida bar, I advocate a lot for realtors. So I'm on your side.
Fantastic.
Any other questions?
Is there room to negotiate with a major home builder for them to change parts of the contract?
With contracts, everything's negotiable. When an attorney is involved, as an attorney, I will get in contact with their attorneys or with their legal department, whoever drafted the contract. And that's who I start the negotiating with. So I don't go to the salesperson where you as the realtor, you deal with the salespeople, with the sales representative, with whoever the person is representing the company. I deal with their legal department. With every contract, there's room for negotiation. And this applies to commercial contract as well. We negotiate commercial contract terms and conditions, and we go back and forth with those attorneys that are drafting those contracts because with commercial contracts, those are also drafted by attorneys. So we tend to go back and forth and negotiate until we get to a midpoint. So yes, everything is negotiable.
Gretchen, we have a couple of things, and some of this was decided while you were out. Yes, we do want a class on the new build contracts, and yes, we do want a class on the addenda as well. So we'll be having you back. Any other questions for Gretchen? No.
I see here from Ida. She's asking, can you share an example with this market, what you were able to negotiate? Can you elaborate a little bit more, Ida?
Well, basically, you say that you can negotiate, and I do understand that anything is negotiable. For example, with builders, they are now just like any other seller, provide the highest and best offer. So, if there's any questions, what can you negotiate? That's basically.
Okay, so just to give you an example, and it's going to be very general because I can't go into the details, but there was a client of mine, and he paid for the buyer wanted me to represent him, so it was the realtor and it was myself, and there was a builder contract, and the builder, he was going to give a big down payment, and he didn't want to lose his down payment or the deposit, how you would call it. It was going to be over $100,000 for that property, and the rest was going to be financed. We knew going into the transaction that there was going to be an issue because it was a foreign buyer. So what we did is we added a clause to that contract where if the issue was due to this, that it was known at the time of the signing of the contract that he will be able to get his deposit back. And thankfully he was, because he was not able to get financing due to his immigration status. So that was one of the most recent ones that comes to mind. And
So
it was $100,000.
So for instance, what would that have cost that buyer to have your services to do that for him?
So in that sense, we negotiated that clause and we added, it was around $550, which is not a lot, provided that he would have lost $100,000.
Right, exactly. Yeah.
But
I could just,
it was
I
very
did it.
simple. It was very simple. I mean, it was simple on my end because I understood the contract. I was able to get, we knew coming in, he was very upfront with me. And that's another thing. And and this is a recommendation to all of you. Make sure you know your buyers and your sellers. I teach I'm a faculty member with the Florida Realtors as well. And I teach the probate class. And it's amazing how many of the real estate agents don't know who their buyers and their sellers are. Remember, this is a relationship business. So you're building that relationship with that buyer and that seller. You want to know as much as you can about them, because had he not mentioned that and had the realtor not asked the right questions, he would have just given the $100,000. This would have never happened and he would have lost his money. The reason why we were able to know this is because we asked all the questions. We got to know the buyer. We got to build a relationship. The realtor was excellent and built out that relationship with his buyer, and we were able to do this for him. And guess what? Now he's buying multiple properties and he's doing it through an LLC because we were able to figure out how he will be able to buy those properties, and that realtor is the one making that commission. So this is all about your credibility, about you building that relationship with your buyers and your sellers. So with this major updates, I think the main point to take away from this will be to build a stronger relationship. Now there's a lot of probate happening, a lot of divorces, and one of the biggest issues that we've had here at offices are buyers and sellers calling us to sue realtors because the realtor told them, no, if you have not lived with your significant other for this amount of time, it's fine. We can go ahead and they don't have to sign at closing, or you can buy the property. The most recent one where was a realtor told their buyer that they could buy the property and they do a quick claim deed from her husband that was estranged. They had been separated for many years, and that's not the case. It doesn't work like that. There's only two status in the state of Florida, and that's divorce and single. We don't recognize separation. We don't recognize that you're in the process of divorce. There's just those two status. So I can't stress this enough. Build that relationship, and when you build that relationship will go on and on and on. And as an attorney, if we can't do the transaction this specific way, I will always try to find another way that we can do the transaction. With this buyer, we were able to structure an LLC. We were able to get an ITIN number, and we were able to get him to buy multiple properties instead of that just one property. And the realtor's making all those commissions.
Do you do probate?
Yes. So I'm a real
Okay.
estate. I'm a real estate business and probate attorney.
Now your probate, because I have a guy out of state, do you kind of have is there like a sort of a set fee that's standard, or is it based on whatever you have to do for that particular client?
So
The probate fee.
I teach the probate class, and there's 3 different probate administrations. There's the full summary administration, there's the full administration, full formal administration, there's the summary administration, and there's an ancillary administration. Those 3 entail completely different scenarios, but those are the 3 most common ones. The full administration is when the actives or assets and properties, they exceed $75,000, and that one takes about 18 months, and it's not a set price because it is a statutory rate. The summary administration tends to be where I give the flat fee, but the summary administration is where the assets don't amount to an amount greater than $75,000, and that's excluding homestead property. So let's say there's homestead property, primary residence, and then they have maybe a retirement account, or they have $75,000 in cash. That we can do a summary administration on that one, provided that no one's going to contest the probate. We could go ahead and do a summary administration, and it ranges from $2,500 to $3,500 depending upon the particular situation. But I do teach that class with the Florida Realtors Association, and we can do and I also have like a separate probate 101 class that Ryan if you have realtors that are interested, I can go ahead and teach that class as well. And I go through as much as I can to provide you with the tools to navigate the process. Because again, with that process as well, if you build your credibility with your buyer or with your sellers, when we go through the process, you don't have to wait until we're done with the probate clause, the probate process to sell that property. So all I speak about, I mean, I can go on and on, but all of that I teach in that probate class.
I'm going to give someone your name, whether he calls you or not, but I'm going to give your name.
Okay. Yeah, I've been doing this. It's one of the things that I like. And you know, it kind of, and the reason why I practice in these 3 areas is because they kind of correlate. So contracts, real estate, a business, and probate, they all kind of correlate. So with each other. So yes. And that's a good class, Ryan. I think all of you realtors should take that class because now with everything that's been going on, one of the things that we're expecting for 2022 is that, you know, all the deaths that we've had from 2020 and 2021, those are all properties and estate that will go into estates. And so there's going to be a lot of proceeding. We expect a 30% increase in probate proceedings. And so as a realtor, if you haven't faced that situation as of yet, you will soon. And also with divorces, we're all-time high with divorce filings as well. So again, you will be facing that situation too. And you want to make sure that you are apprised of that information so that you can navigate those processes with your buyers and sellers and still bet the realtor of contact. So a lot of good information. Any other questions?
Do you do estate plans and trusts?
Yes, I do, because it's part of probate. So yes, we prepare estate plans. Estate planning is a great tool to avoid probate. So if you have clients that have assets more than just the homestead property, you want to recommend that they speak to an attorney about creating an estate plan, because Florida is a probate state, which means whether you die with a will or without a will, you still have to go through a probate proceeding. And there are ways to avoid that. And there's even a simple way as a ladybird deed. And, you know, I had realtors call title companies. Title companies cannot draft a ladybird deed because they're not attorneys. So they will refer you out to me. So if you're closing with a title company, not with a real estate attorney, then you will be faced with that situation. But I can draft a ladybird deed and avoid probate for a lot of clients. I'm sorry, I have my little puppy here with me. Any other questions? I'm at home getting ready for my Thanksgiving, so there's my puppy running around. Any other
Thank you.
questions?
Great information, Gretchen. Nice meeting you.
Thank you.
Speaking of a ladybird, I just had a client, a couple months ago that had a ladybird, and it made things so much easier.
Yeah.
So people need to pay attention to that word. It's very important.
Yeah,
If you
and I
don't know what it is.
Yes, Sarah, and I talk a lot about the ladybird deed during my probate class, the one that I teach for the Florida realtors, and the probate 101 that I usually give just to realtor offices, because the ladybird deed is an excellent tool to avoid probate when it's just one property. It's an excellent tool. But again, my realtors call title companies and then they call me, they're like, my title company can't do it. Of course not. That's legal advice. They can't cross that line. And you don't want to cross the line. So if you think of this will be a great person for ladybird deed, just go ahead and give them, even if they're closing with a title company, I can still draft the ladybird deed. We can still get it done after the closing. You just have to be in contact. So communication is important. Just have your team of experts, your accountant, your broker, and your legal advisor, so that if you have any questions that are outside of your realm, we can answer those for you.
Hey, Gretchen, if you do quick, you said you can list the property while you're doing the probate? Or
Yes.
going through the probate? You can do that, right?
Yes, because the first thing that we do, and it's all very case specific, but just to give you an example, if right now I have a probate proceeding and it's a summary administration, there's only one property, which was the deceased homestead property. And the first thing that we do when we file a petition to open the case is we file a petition to determine homestead. Once we get that, the property is outside of the probate, I call the real estate agent, let them know, hey, you're ready to list, and you can go ahead and list the property. property. Or if they want to sell within the estate, let's say it's an investment property, not a homestead property, then we maybe 3 to 4 weeks into the probate proceeding, I file a petition to sell the property, get an order to authorize the sale of that property, and you can sell the property, and then the funds will go into the estate, but the realtors gets paid first as soon as the property is sold.
Thanks, Gretchen. Thank you.
You're welcome. Any other questions? Well, with that, I hope everyone has a happy Thanksgiving. I know I went a little fast with the contract revisions because I don't know, for some reason, we're having issues with the Zoom. But if you have any questions, feel free to reach out. You have my direct number, that mobile number that I provided to you at the end of the slide. And I'll put it here on the chat for everyone. Let me go ahead and do that right now. Just shoot me a text message, shoot me an email, and I'll be happy to help with any questions that you may have. But again, just keep in mind, now build those relationships. And if you look at it from the positive perspective, if you build those relationships, those are people that are going to stay with you at the long run. And if you know how to, just refer to legal counsel just for their protection, and you make it seem like it's for their best interest, they'll be grateful. You'll build the credibility, you'll build a relationship, and you'll, be able to get that business. So thank you everyone for being here today.
Gretchen, real quickly, going through the chat, this was awesome. Great information. Thanks, Gretchen. Happy Thanksgiving. Thanks, Gretchen. This was great. Thank you, Ryan, for putting this together. You're the best. So all that stuff is in the chat.
Ryan's the best, of course he is.
I may have added part of that. All right. Well, thank you very much, Gretchen. We look forward to, we're going to have you on again. Guys, support her business as well. She's there to help you guys and add value to what you do, which adds value to your clients, which gets you more business, like she just said.
And I'm fluent in Spanish, English, Spanish, and Portuguese. So if you have any clients that speak Spanish or Portuguese, feel free to reach out. And then the one last thing that I wanted to say was thank you, Ryan, for having me here today. And if you want this class in Spanish, I can also do it in Spanish.
Fantastic.
Okay.
Yeah, thank you very much, Gretchen. I appreciate it. Happy Thanksgiving to you and to all of you guys. We will see you next week, and we've got something else planned next week, and then we'll have Gretchen on again in a little bit. All right.
Thank you.
Thank you, guys. Happy Thanksgiving, everybody. Bye-bye.